Welcome to a brand new episode and season of Law and Batting Order. I'm your host, Tony Oyakostas. Be sure to stay tuned at the end of this episode for some programming updates and comments regarding Law and Batting Order's one-year anniversary. Anyway, here are some quick hits from the past 2 weeks. Mets fans like myself rejoiced when R.A. Dickey won the NL Cy Young Award for his stellar achievements this year. From climbing Mount Kilimanjaro earlier this year, to writing a biography, to winning 20 games, R.A. Dickey was the Mets fan version of Chuck Norris. Epic, invincible, and downright awesome. But many Mets fans have mixed feelings as the Mets have traded Dickey to the Blue Jays for Toronto's top prospects Travis Darnard and Noah Syndergaard. The Jays get a potent pitcher in Dickey and they instantly become playoff contenders. Meanwhile, the Mets acquire young talent in an effort to create a formidable future for the team. Hopefully this trade pans out for both sides, and on behalf of all Mets fans around the world, we wish R.A. Dickey nothing but the best. The situation in the NHL has grown more tense as the lockout looms. Not only have games been canceled through January, but the NHL has filed a class action lawsuit against the NHLPA for unfair labor practice and claiming that the collective bargaining initiatives made by the NHLPA were made in bad faith. The NHL also asserted in their complaint that their 90-day lockout is legal. In response, the NHLPA has approved the first step to decertify their union. This is significant because decertification allows the players to file an antitrust lawsuit against the NHL as per the Sherman Antitrust Act. We saw this similar activity in the summer of 2011 when the NFL Players Association filed an antitrust lawsuit against the NFL. Much has yet to be determined regarding the future of the NHL, but the future looks rather bleak. The NFL season is winding down, and it's at this point of the season that we will see who will advance to the playoffs and who will be eliminated. The NFC East is particularly interesting as the Redskins, Giants, and Cowboys are all tied at 8-6 at the time this episode was filmed. The next 2 games are especially crucial for each team, so their entrance in the playoffs will boil right down to the wire. Meanwhile, in the NFC West, the 49ers are facing stiff competition against the rising Seattle Seahawks, who have been playing incredible football recently. But it wouldn't surprise me if the potent offensive force of the 49ers shoos away the Seahawks from playoff contention this year. Today's Order in the Court will be discussing the use of trademarking in sports. Intellectual property law has slowly become an important branch of law in recent years as more and more people protect their intellectual property via trademarking. We have especially seen this in sports with athletes protecting slogans that bear some relationship to their image as an athlete. To help us take a look at trademarking and the implications that it has in sports, it is my privilege to welcome back a good friend of Law and Batting Order, Ben Haynes, who is an attorney based in Florida, and he specializes in intellectual property law. He is also a contributor for sportsagentblog.com and sportinlaw.com, has helped co-author some articles with Darren Heitner for Forbes.com, and he's a former member of your Oral Roberts Golden Eagles. What a resume, Ben. Welcome back. How's it going?
It's going great, man. Thanks for having me.
Yeah,
again.
You got it. So let's dive into the subject of trademarking since it really is an important aspect of intellectual property law. But let's take a step back and look at intellectual property law with respect to copyright and trademark because people tend to misconstrue the meaning of copywriting and trademarking. So As an attorney who deals with intellectual property law on a daily basis, can you distinguish between what a copyright is and what a trademark is?
Yes. And a lot of people do get these mixed up. What a copyright does is that protects original works of authorship. So you're thinking music, movies, even art, paintings, stuff like that. Where a trademark is more of a source indicator of where the goods or services come from. So, for example, when you see the Nike symbol, when you see the swoosh symbol, you're thinking, well, that's affiliated with the company Nike. Now that's what a trademark does. It just identifies who owns the mark or who owns the good or the service that's being provided.
Right. So now for the purposes of our chat, we are going to dive into this trademarking topic. So something like the swoosh logo is a trademark. And now trademarking is a very popular practice, especially in the sports industry. So what is the process by which someone can trademark a slogan or a logo?
Well, it's a very long and tedious process. And the most important thing to do, first of all, if you're wanting to consider filing your trademark, is to do a search. It's best to have an attorney usually do the search who's had experience. Unlike you, Tony, who got your trademark filed on your own, you haven't taken IP yet. It's pretty incredible. But you file that search to see if you're going to be conflicting with a mark that's already been registered. The standard is there a likelihood of confusion to a consumer who would see your mark compared to a federally registered mark? Are they likely to get confused if that second mark and consider it affiliated with the first mark? If so, your chances of getting your mark registered aren't very good. You'll likely get refused. But the search is the first and foremost. Second, when you have to decide what classification your good or service is going to fall under. Now there's 45 separate classes. There's 34 classes for goods, and there's 11 classes for services. You have to, like I said, you have to determine which class your either your good or service is going to go under, and there's a separate filing fee for each class that you want to go under. So while preparing the application, like I stated before, it's best to get an attorney with experience because it's very detail oriented, it's highly technical, and if you even make a minor mistake, the USPTO office will likely, they might not reject it, but they'll issue what's called a non-final office action and ask you to correct some of your errors that might have been in your application. So it's an extremely tedious process, but my biggest advice to anyone wanting to do this is make sure you search, and if you're at all concerned about there being conflicting with someone else's mark that's already registered, consult an attorney and go from there.
So, and now you are not endorsing me to handle trademarks, and I am making sure for the public out there to not go to me at all for trademarking, especially since I don't have the IP experience. But nonetheless, you did bring up a good point about this tedious process, and as you alluded to, which is true, I just completed the process of trademarking the lawn batting order logo. But one of the things that I noticed, aside from the whole classification system, assigning whether or not it's a service or a good, or just going through that whole process, one of the key details, well, one of the key factors that I noticed is that the whole process of trademarking is very long. I mean,
Right.
I trademarked the logo for lawn batting order back in June, and I didn't get a confirmation until the end of November, around like November 29th, 30th, that the logo was officially trademarked, and then it was put in the catalog. So, can you explain why the trademarking process is such a long process?
I think first off, when you're dealing with anything with regards to a legal situation with the courts or whatever you're dealing with, it's a long process no matter what. It's tough. You have to develop patience for it. I get clients all the time who are wanting updates, the day after something's filed. I'm like, it's going to take time. You just relax. There's so many trademarks. There's so many people filing for trademarks that it takes usually from the time you file your application to the time it's examined by a USPTO attorney. It's about 3 months usually. Now, they'll usually examine it within a week of when it's assigned to them, but in some instances, like I stated earlier, they'll issue something called a non-final office action, which gives the attorney or the person who filed the application some problems that the USPTO office sees that they would like fixed, and then that attorney then has within 6 months, I believe it is, to file a response to the office action. So usually, I mean, in your instance, that's awesome that you already got it's already been registered. I mean, in 6 months, that's a pretty fast, 6-7 months, that's a pretty fast trademark in my opinion. But usually, I would say at least takes a year. If there's any issues with it, it can take up two to maybe even 3 years. So it's a long process.
That's really something. Actually, I'm glad. I'm kind of encouraged to hear that news. So now, in the world of sports, let's apply this knowledge of trademarking because we have seen athletes pursue trademarks of slogans. So, for example, Anthony Davis entered the NBA draft and pursued a trademark for the slogan "Fear the Brow" and to pay homage to his unibrow. Tim Tebow trademarked Tebowing, but it wasn't for the gesture. It was just for the phrase Tebowing since it has his name in it. And then now more recently, we have the issue with recent Heisman winner Johnny Manziel, who could be pursuing a trademark for his nickname, Johnny Football. So let's start with the broad question. Why is it important for an athlete to trademark a slogan? Is it because the slogan is a moneymaker that he can market in the future? Is it because the player wants to maintain full control of that intellectual property right? What's the rationale?
I think all the above. I think when you have a slogan that can potentially, or a mark that could potentially earn you money and be very valuable in the future, then you want to file your application ASAP so that you have rights superior to whoever else is thinking of that idea at a later time. And the advice I give some of my clients is, even if their mark, let me just take a step back. You can either file your mark under a 1A basis, which means your mark is already in commerce. It means you've already sold it before. And then there's also under 1B, which is your intent to use in commerce. So for an athlete, like say who's in the NCAA, if he's not going to be making money off his likeness, because we know he can get in trouble for that. So you'd file under a 1B. Now you'd still have the rights to that trademark over someone else who files after you, even though you don't have it used in commerce. But the key is just filing that application, getting it out there, letting it be known that you plan on taking control of that mark, and getting that federally registered. It's very important to do, because it potentially could make that athlete a lot of money. And since athletes, especially the higher end athletes could be famous. Well, that for instance, the fear of the brow, that mark could end up making Anthony Davis a lot of money. And if he doesn't file that, someone else could be making money off that slogan, which really does belong to him.
Right, exactly. And on top of all the endorsement deals, I'm sure he wants that intellectual property right, because it
Right.
essentially belongs to him.
Exactly.
So now, one issue that does come up involving trademarks is infringement. It's pretty common. I'm sure you can speak to that. And
Right.
we saw this earlier this year with Oklahoma City Thunder star Kevin Durant and musician Mark Durante, where they were both feuding over the nickname, or the name rather, Durantula.
Right.
Now, drawing from that example and other examples involving infringement of slogans, what is the common route that a player can take in case that a trademark is infringed, or the player believes that he has rights over that particular trademark?
The first advice I would give is to gather all the information and really weigh whether or not it's worth going after somebody for infringement. The first thing that you'd want to do is, if you do gather all the facts and you realize that someone is infringing and it's unauthorized, then you want to have an attorney draft up a letter, send it to them, letting them know, hey, I have a federally registered mark. Here's our registration number. You're infringing on my mark that is protected. Please, cease from doing so right away. If they don't do that, then what you can do is file a lawsuit in federal court. And not only would you ask for an injunction, but you would also ask for money damages, including attorney's fees, if they're willfully infringing on your mark. But the main thing that people want to do is just, they want them to stop. So if you send out a letter asking them to stop, saying, hey, I have rights to this, you're infringing on my rights, usually someone who's smart will usually stop infringing. And it's amazing. I mean, we're talking about athletes here who have marks. I can only imagine how many people actually infringe that people don't even know about. Just from some of my clients, even smaller businesses, if you just run a regular trademark search, or even on Google, it's amazing how many people who are just using someone else's mark, and maybe the federal registered person doesn't even know about it. So there's infringement all over the place. So you really have to do a cost-benefit analysis, really, of whether it's worth going after someone. But you do definitely want to protect your mark, because, for instance, if someone else is out there infringing on your mark, they could be giving your company a bad name from using their mark in a way that, like I said, makes the federally registered marks company look poor. Right. You don't want your company diminished by someone who's infringing on your mark. So that's really one of the main reasons you'd want to get that injunction against the infringer.
Right. That makes sense. So now let's flip back to the Johnny Manziel example, since he could very well be filing a trademark for the Johnny Football slogan in the near future.
Right.
Now, we sort of tread on thin ice here in this area because, as you alluded to, Johnny Manziel is a member of the NCAA. He's a college football player. And, if he were to potentially collect revenue from this trademark, he would be in violation of the NCAA rules regarding compensation, and we've talked about this many, many times on Law and Batting Order. So, I guess it's sort of like an iffy question here, but You had mentioned that he would probably most likely have to file a 1B application for trademarking here. But let's suppose he doesn't. Let's say that he goes for a 1A application here for trademarking.
Right.
Will he then expressly be violating NCAA rules if he were to collect money from that trademark? And could there even be an issue of maybe, maybe sort of like creating some sort of resolution to this so that maybe an NCAA athlete can market from that trademark? Or does this all go back to the whole general argument of pay for play?
Well, yes, to answer your first question, he would be in violation. He'd be making money off his likeness, and you're not allowed to do that for some reason when you're an NCAA athlete. Do I believe that he should be able to make money off his likeness even while he still has eligibility as an NCAA athlete? I definitely do. I think whether that's 100% of the profits from his likeness is up for debate, because I've heard this argument before, and I think there's some merit to it. Without the NCAA and without Texas A&M, would he even have a chance to have that mark filed? So why should he get 100% when the NCAA and the school does have some reasoning behind him even having that mark be popular? But then you get into the whole argument of, well, how do you determine how much each side gets? But I definitely don't think the NCAA should be able to say that this player doesn't have any right to his likeness. I'd like to see that change in the future. The Ed O'Bannon case with regards to to the player's likeness, that's still pending. So it should be interesting to see how that pans out. But for now, he's going to file it under a 1B intent to use, and then in the future, if it's still popular and he can make money off it, then he'll switch that to a use in commerce. So.
Let's hope for his sake that it remains popular. So,
right.
So finally, trademarking is a branch of IP law. It's slowly becoming popular. What role do you see trademarking playing in the future for athletes?
It plays a huge role. Just to summarize everything we've talked about, if an athlete feels like they have a slogan or a nickname or something that they can potentially benefit off and make money off of in the future, they want to file that trademark. It's so important. I hear people all the time, well, I'll do it later. Listen, there's a lot of people making moves, and if someone else files that trademark before you and they have that application even pending, if it's approved, before you file, you're going to be playing second fiddle to whoever has that federally registered mark. So it's important to get your mark registered. Not only so, but because it does take so much time, you want to make sure you do it right. Because first of all, you want to file the search, like I stated. Second of all, you want to make sure your application is done right. I would seek an attorney with experience to do that, unless you're Tony, who has the skills to do so. Because it's not only like I stated, it's not only that you're losing money, because if the USPTO office comes back and says, hey, you have issues, we're not granting your trademark because you just didn't file it properly, well, you lose that money, but the biggest thing you lose is the time. It takes at least 3 months for an attorney to even look at it. So then you're really starting all over. It can be frustrating to people. But it's something that every athlete who has potential of making money in the future off of it, it's something they need to seriously consider. Seek a trademark attorney and people who have experience, who enjoy doing it, and get that application filed correctly right away.
Definitely the route to take. And certainly we have a lot to yet to see in terms of athletes trademarking their slogans and whatnot. But of course, trademarking is a lot of fun to follow. It's something that I'll be taking a look at next semester with IP class, with my IP class. But Ben, it's always great to hear your insight on these issues. I wish you and your family a very, very happy Merry Christmas, and thank you for being on Law and Batting Order.
All right, congrats to 1 year anniversary for Law and Batting Order. Thanks for having me, buddy.
Thank you very much. Before I wrap up today's episode, I'd like to make 2 announcements. The first is that beginning the new year, I will launch a new programming part to Law and Batting Order called The Huddle. The Huddle will be an interactive roundtable discussion that will discuss a contending legal topic in sports. In episodes that feature The Huddle, there will be no quick hits, and it will be a substitute to Order in the Court. Episodes featuring The Huddle will be intermittent throughout the year, so be on the lookout. And secondly, as you are well aware, today is the 1 year anniversary of Law and Batting Order. What a privilege it has been to serve as this show's host for 1 full year. From talking about contract law issues to having a plethora of notable sports law professionals as guests, I can't begin to tell you how blessed I am that Law and Batting Order has served as an outlet for me to discuss sports law issues, and my hope is that Law and Batting Order will serve as an aid and as the go-to show to discuss sports law issues. As I enter year 2 of Law and Batting Order, I am committed to improving the show's content, having more sports law professionals appear as guests, and, in general, raise the show's bar. With that said, I want to thank each and every one of you out there who has watched either one episode or all of the show's episodes, who has tweeted or liked Law and Batting Order's Facebook and Twitter pages, and who has shared my videos with friends, family members, colleagues, and other legal professionals. I am very sincere when I say that this show's success would not be possible without you, the viewers. Anyway, that's the show. Leave all your comments down below, and be sure to visit Law and Batting Order at lawandbattingorder.com, as well as on Facebook and Twitter. Merry Christmas, Happy belated Hanukkah, Happy Kwanzaa, and Happy New Year to all. Take care, guys.